Thank you, Mr. Chairman, and thank you for your dedication to the issue of name, image, likeness. I know this. Name, image, likeness. I know it's close to your heart to ensure college athletes have every chance to succeed professionally and academically. We're fortunate to have a few former college athletes on this committee, and I know it's an issue that's close to their hearts as well. I'd also like to thank Mr. Pat Chun from Washington State University, the athletic director for Washington State University, who's testifying today. Go Cougs. He's been a leader on this issue, his work at WSU and various roles with the NCAA. Just appreciate your insights.
Our next witness is Pat Chun, who is the director of athletics from Washington State University. You're recognized, sir, for 5 minutes.
Thank you, and good morning. And Subcommittee Chair Bilirakis and distinguished members of the subcommittee, thank you for the opportunity to appear before you today to discuss protecting name, image, and likeness rights for college student athletes. My name is Pat Chun. I've worked in college athletics for over 25 years and currently serve as the Director of Athletics at Washington State University. WSU is a public land-grant research institution. Our athletics program sponsors 17 varsity sports comprised of nearly 500 student-athletes, including the reigning Pac-12 Conference women's basketball champions. The mission of WSU Athletics is to unleash excellence and provide a transformational student-athlete experience. WSU Athletics prides itself on being one of the most fiscally efficient athletic departments in the country, with our budget consistently ranked amongst the lowest in the Power 5 conferences. Our student-athletes currently hold a school record 3.22 cumulative grade point average, graduate at an 8% higher rate than the general student population, while also earning a 91% NCAA graduation success rate, the highest in school history. Also, more than 20% of our student-athletes are first-generation college students. College athletics is facing significant challenges with no simple solutions. Last year, I met weekly serving on the 21-member NCAA Division I Transformation Committee. At our conclusion, recommendations were submitted to the NCAA Division I Board of Directors and approved in January. These recommendations introduced the holistic model for student athletes, setting expectations for the support of their health, safety, and well-being, called for elevating the championship experience, and created a fairer, faster, and equitable NCAA governance model. Nevertheless, significant challenges remain in college athletics. The primacy of academics is at the foundation of every institution of higher education. While college athletics has evolved into a multi-billion-dollar industry, our mission remains to educate young people and prepare them for their respective futures. Proposed state legislation and ongoing litigation may impact student-athlete employment status, and the issue threatens to cause irreparable damage to the student-athlete experience. Certain aspects of a potential employer-employee relationship should be considered with caution. The notion that a student-athlete could be fired for underperformance undermines the very core of the educational mission. Additionally, transitioning to employment status could erode many of the benefits and guarantees that student-athletes currently receive through potential tax implications. Lastly, if one group of student-athletes becomes employees, such as those in high revenue-producing sports, demands and legal claims could be made that all student-athletes should become employees. The financial impact could lead to the reduction of opportunities for broad-based participation on campuses around the country, resulting in significant Title IX implications, threatening generations of hard-fought progress in women's sports. NIL was intended to be the next significant benefit for student-athletes. Like any other student on campus, student-athletes deserve the right to monetize their NIL based on their reputation and platform. Although true NIL provides tremendous opportunities for student-athletes, the existing environment consists of recruiting inducements, tampering, and ultimately pay-for-play, and is wrought with pitfalls and misinformation. Recent reports in the media suggest that current student-athletes across the country are being approached with empty promises, which lead to false expectations. There is a probability that inequity exists in the NIL marketplace. One example is from research provided by Navigate, a sports data and valuation company. The research focus on compensation for influencers states that approximately 77% of the general, meaning non-college athletics, NIL compensation is earned by women. Comparatively, the research suggests women student athletes are receiving just 16.2% of the college athletics NIL compensation. These numbers support the widespread belief that the collegiate athletics NIL market is not reflective of the true value of a student's NIL. Without disclosures, institutions and student athletes are not able to properly assess NIL opportunities for fairness and equity. By shielding accurate and required transactional information, third parties have profited from the uninformed decisions of student athletes. Only with transparency, oversight, and uniform regulation will unscrupulous third parties begin to act with the best interest of student athletes at heart. On behalf of Washington State University and our president, Kirk Schultz, we are committed to being a part of the solution. We respectfully ask Congress to partner with the NCAA and our member institutions to develop federal standards that provide transparency and enforceable safeguards to mitigate the negative impact of the existing NIL environment. This will help ensure student athletes benefit from the full potential of their NIL. It is also vital that we affirm the current relationship between student athletes and institutions. WSU supports meaningful oversight that provides protection and value to the student athlete and ensures that institutions and outside entities are complying with standardized rules and governing policies. Thank you.
I wanted to start with Mr. Chun. Just thank you for being here again. And while there's certainly differences in resources, even within the Power Five, you represent an institution with lots of resources for their student athletes. Would you just walk us through the ways that you're helping support and educate young student athletes at WSU as they're approached by agents, collectives, and large dollar NIL deals?
Well, first and foremost, Madam Chair, thank you for the leadership you provide to Eastern Washington, and we appreciate your leadership on this topic. At Washington State, our goal is to empower, educate, and protect our student athletes. Our program is actually similar to what is going on at Florida State. We take great pride in, prior to the NCAA allowing NIL, we partnered with our Carson College of Business. We have a credited course on campus that goes through all the major points of NIL, from tax education, managing your social media, contracts. So that is really probably our biggest piece. We also have full-time staff that we currently employ that works directly with our student athletes. As you're aware, in the state of Washington, we do not have an NIL law, so we are governed by state ethics laws. So that is prohibitive on what we can do in terms of directing our student athletes with collectives and with deals. But ultimately, we provide as much education and introductions as possible with our student athletes while complying with Title IX, NCAA rules, and state of Washington rules.
Thank you. Would you speak to what you believe would become of school programs, conferences, if we fail to provide federal certainty to the NIL landscape? And how do you see the NCAA factoring into this future?
Well, let me make clear, true NIL is extraordinarily positive for our student athletes, and that needs to continue. It's what is going on with recruiting, inducements, with some of these collectives that are ultimately are fraudulent in what they're doing with NIL. And that is, I mean, I read this morning, I'm tracking on Florida Atlantic University. I used to work there, and their extraordinary run to the Final Four. In the Palm Beach Post this morning, the head coach is already talking about tampering by third parties to his existing roster. That's been happening for weeks. And we have rules today in the NCAA that don't allow tampering, that don't allow inducements, but because of the disparate state laws, the NCAA is at a point now where it is incapable of enforcing those rules. So where this thing heads is concerning, because as we continue to spiral away from any type of commonality with recruiting, with the impact it's having on student athletes in terms of just the amount of noise they have to deal with, as stated earlier, the value of the degree is what our focus on in higher education. But I do see impacts if where we're headed ultimately leads to 5 conferences or a subset of schools in those 5 conferences having to deal with this environment in a different way does have a negative impact on the rest of Division I, Division II, and Division III. I mean, it's clear the business model of NCAA is what we'll see this weekend at the men's Final Four. Yep. That funds the entire operation.
Thank you.
Mr. Chun, would you like to respond to Dr. Stahl on that issue? And if collective bargaining were to take place, what resources would have to be relegated, perhaps to the detriment of students?
Complicated question.
And I only have 10 seconds.
I mean, ultimately, we're in a model that puts a primacy on academics, broad-based programming, opportunities for men and women across multiple sports. Anything that you look to my right, how is a football player unionized or an employee, and a softball player isn't? We can all sit here and know the inputs are the same. She's putting as much time in as he did on the in the weight room, in the classroom, in the practice field. There is no difference other than the venues in which they play in and the amount of viewership. That's it.
Thank you.
In the recent Alston v. NCAA ruling by the Supreme Court, Justice Kavanaugh wrote in a concurring opinion that the current NCAA model is suppressing the pay of student athletes who collectively generate billions of dollars in revenues for colleges every year. Those enormous sums of money flow to seemingly everyone except student athletes. College presidents, athletic directors, coaches, conference commissioners, and NCAA executives take in 6- and 7-figure salaries. Colleges built lavish new facilities, but the students who generate the revenues, many of whom are African American and from lower income backgrounds, end up with little to nothing. Mr. Chun, what are your thoughts on Justice Kavanaugh's observations? Is that an accurate characterization of the current system?
The primacy of academics is the number one priority of college athletics. The greatest factor today in social mobility is still a college education. Our business model is flawed. On most campuses, it's 1, maybe 2 sports, at least at our level, that provide resources and revenues to fund the rest of the athletic department. And oh, by the way, we're legally obligated to follow Title IX. So access, opportunity, there has to be equity. So the model that we have currently provides extraordinary opportunities for multiple student athletes. And oddly enough, there's a certain segment of schools, because of this men's basketball tournament, that provide opportunities, like Dr. Abdullah said, to 500,000 student athletes across 1,200 institutions across 3 divisions. So there are inherent flaws in the model. I recognize that, but the reality is those flaws have created this opportunity for countless student athletes.
What are the effects, positive or negative, from the money, the boosters' money going to those collectives rather than the AD, to the athletic department?
Well, the positives, assuming that there's real work going on around the country, we want to do more for our student athletes. Real NIL work we're 100% supportive of. It's what's going on with the inducements and the tampering, that's the challenge, and that's where we need the help. With federal legislation, with transparency, with something that proves that there's real work, something that provides clarity for Title IX. Across many campuses, you can read it. You could read it almost daily in sports articles of coaches, administrators, assistant coaches involved with supporting and advocating for collectives. Are they representatives of the institution? Does that trigger Title IX? And also, we probably need something that takes into consideration international student athletes.
I was also concerned about the revenue being diverted and then therefore may not be available to distribute to the other sports.
Well, yeah, the collectives are a little bit different because those are going right to the student athletes. As long as there's equity and as long as there's real work, there's no issues. It's with the inducements and with the tampering that is where all the challenges are coming.
Well, thank you, Mr. Chun.
As some of my colleagues have rightly pointed out today, the emergence and embrace of NIL collectives has created a number of questions over the past year and a half. Mr. Chun, are you familiar with the Cougar Collective, the NIL collective associated with WSU?
Yes.
And do you or athletic department staff, including coaches, communicate directly with members of the Cougar Collective? And if so, do they discuss potential recruits that a team may be hoping to land a commitment from?
Not with me directly and not to my knowledge with any of our coaches. Our interaction with them has been education. They've done compliance education with us. Really, we meet, our compliance staff probably meets with them at least, I think they have a standing meeting once a month just to ensure compliance with the rules. We're fortunate our collective is filled with alums that care about the institution that are really focused on following whatever rules exist. And we do not have an NIL law in the state of Washington.
So I've I think one of the things that we need to talk about when we're talking about these collectives are whether or not, there are conversations about specific athletes in tandem with universities. Mr. Chun, is it your understanding or your belief that the Cougar Collective prioritizes women athletes as equally as they do male athletes?
I know they've had conversations. We do not have access to what exact deals are happening, but I know they have communicated to us that they're working to try to find opportunities for our women. They understand at our institution specifically, our women's sports are performing at pretty spectacular levels. So they recognize the challenges that our women coaches have as well, but we do not, we don't have any clarity exactly on what the deals are.
Mr. Chun, we've talked about this a bit, but over 30 states have passed laws relating to name, image, and likeness rights. Some of these laws have been in effect for over 2 years. While the need for a uniform policy is understood, can you cite specific examples where a state was significantly advantaged or disadvantaged as compared to another state, and the impacts they have had on a student athlete monetizing their name, image, likeness?
Well, I can just cite our own state because we don't have a law. Initially, I thought that would be to our advantage and give us flexibility, but in all reality, we're governed by state ethics laws. So it's really restrictive on comparatively what other states are doing. So in the state of Washington, really they're limited to education, but we can't steer our student athletes towards specific deals or work with collectives as it has been legalized in some other states.
Mr. Chun, it's my understanding that NIL Collective can offer student NIL deals before they commit or show up on campus. First of all, is that correct?
Not based on NCAA rules, but probably different by that part of the issue with the patchwork of state laws.
And so my question is, how do we ensure that NIL deals aren't being used to persuade students to pick certain schools?
That's why we need a federal standard.
Some people have proposed ideas like making student athletes employees of the university. How could this hurt smaller sports and smaller universities, and will some universities choose to get rid of intercollegiate sports programs altogether?
I don't know how you differentiate one sport from the other relative to the employment. So like I stated earlier, the inputs are the same, the commitment, the sacrifice, all the things that go into being a student athlete are no different for a softball player, volleyball player, football player, or basketball player. No difference between our men's and women's basketball programs. I don't know how you cite one as employees and the other one not. So it's just fundamentally flawed there. And I also don't, the notion of underperformance leads to firing just is counter to college athletics. It's about academics. It's about earning that degree. It's the immeasurable impact college athletics has.
Mr. Chun, how many athletes in your program since NIL was originated have entered the transfer portal to improve their NIL opportunity?
That's a very good question. That I could not give you an exact number because it would just be based on rumors.
Right. But it happens.
It happens, and it's a reality. I mean, we're seeing it all across men's basketball right now with entry in the portal, and you can see the list, go on social media and see the listing of schools that are so-and-so contacting X person, and but it's the reality of the world we're in right now.
Right. You mentioned that currently there's a team in the NCAA basketball, the coach is tampering. What do you mean by tampering?
So what I read, what was articulated in the story was throughout their tournament run for Florida Atlantic, the coach articulated that third parties are reaching out to his current athletes, and they play this Saturday in their pursuit for a national championship about going to their schools. That is tampering.
Really?
We have, and it's probably at its lowest levels or worst levels.
Right.
Yeah.
Now, as I understand it, on the NILs and where this money's coming from, it's coming from alumni primarily, isn't it? Is that where the colleges are getting the
collectives.
The collectives,
But
yeah.
there's companies involved. I mean, it's a blend of true
alumni.
NIL, and if it's a recruiting.
So, for example, if you had alumni participating, their business participating in this, they wouldn't be apt to want that money to go to, as far as parity is concerned. In other words, if they're doing it for college football, that's where they want that money to go. With that, can they decide or direct the money that they put in the NIL to go to one specific sport or one specific college?
Well, I think if it's true NIL, I would not suggest limiting anything for student athletes. That's true NIL. That's endorsement opportunities. That's that they're paying for actual real work. If it's an inducement or a recruiting tool, tampering, that's where the issues come into play.
Mr. Chun, can you address that question? Agents, how do you deal with that? Maybe the ones who are not so interested in the well-being of your student athletes.
I think I agree wholeheartedly with what was said. We need transparency in the marketplace. We ultimately, and we need to allow our student athletes all the information necessary as they make decisions. We can educate as much as we want. We're no different than probably all the schools represented here, where we go to great lengths to make sure our student athletes understand all the points that go into being in this NIL marketplace. But at the end of the day, they do need some transparency to understand what is out there in the marketplace.
Mr. Chun, I'll go to you. And part of your testimony was interesting, and I'm interested to hear your thoughts on the revenue sharing and, using California's model, what that would do to Ms. Mudge and what that would do to Olympic sports if we had the revenue sharing. And I think traditionally, correct me if I'm wrong, but most of the revenue is going to come from football and men's and women's basketball, and that's kind of the top three. So what does it do to the Olympic sports and women's sports in particular?
Well, I'll answer that from two different angles. One, it's what I'd spoke about before. It's the flaw in our model that two sports do drive on most campuses. Some won the revenue to run an athletic program, and are also governed by equity in Title IX. So it provides opportunities for broad-based programming. Also, as a member of the Pac-12, obviously we're paying attention to what's going on in California, but it's another example of another patchwork state law that's going to impact how we manage college athletics, not only on the West Coast in our conference, but it'll impact other institutions in the NCAA.
I'll kind of look at Mr. Chun, Ms. Heppel. I mean, what if we don't do something now? What is the biggest threat, and what will happen?
I go to what Mr. Burton said. It's about the employment model.
Okay.
And the impact that'll have specifically on 5 leagues or a subset of schools in those 5 leagues, that ultimately, if you look at where the revenue's generated from, ultimately fund the entire enterprise of 500,000 student athletes, 1,200 institutions. So what alarms me is if that path, if the road took us down that path, I don't know how Division II, Division III, and most of Division I exist anymore.
Yeah.